There are many ways we can look at the impact of colonization in the development of international law. In fact, the birth of the international law itself is from the colonization and their powers, particularly. The League of Nations failed, Second World War happened. Then after that, there was a necessity that we needed a strong international organization to maintain international peace and security. So at the time, a kind of a consensus emerged that no more wars. And this kind of a devastation is not good for the future of the countries and the peoples. And we need to go for some kind of international legal order. And that should be effective, not like the League of Nations. So we must, consolidate our efforts, particularly the states which won the international, the Second World War. So they wanted to create a new structure. The powers which won the war, obviously they have the upper hand. They grouped together and they formed the alliance with all the states and created the United Nations. And that much is really good. No second opinion on this, that we should not go for such a arrangement. But they have put a seed of such a what I could say, that is it a outcome of a colonization or a kind of hegemonic powers they put in the Security Council while creating the Security Council. So the major impact of the colonization or the power of colonization was implanted in the formation of the Security Council first. If you can see the shaping of the international organization. Even though China, France, Russia, UK and USA, they were the powers there. We expected that they will be. It is only in the beginning that they will be, because they are taking major stakes and efforts to organize this, and they are the winning powers. So they will be working more for the international peace. As the times go by, we realized how this is designed and how this is affecting the international peace, the working of the international law itself. So this is one aspect that we have to seriously look at, that how the P5, the concept of the permanent members there, with the power of veto they have exercised while constituting this structure, and how this is adversely affecting the international legal order. Now we are increasingly understanding this. This is one thing that we all should understand, because this is not the purpose, this is not the wish of all the states when we organized or created the United Nations. Why we are looking at the United Nations in the central part of the development of international law is, the UN brings the platform to create international law after the creation of the UN itself. It facilitates and it guards how international law can be implemented in many countries. And whenever the international law is breached, the forum which is available for us is to go to again either to General Assembly or to the Security Council, even though the General Assembly is alive to the expectations of all the countries. And every time whenever there is a problem in the world, in times of in case of a war or a poverty or environmental issues or human rights violations, the General Assembly has always lived up to the expectations. It comes out with the resolutions, demands the countries to act in a particular manner so that the people's rights, the states' rights are not violated. But unfortunately, when we need concrete solutions, these are only resolutions. The General Assembly resolutions are not binding, but they may act as a soft power, convincing the countries to act in a particular manner. Only to that extent it can help us. But if you want to take hard decisions, immediate decisions in case of emergency in order to stop war, in order to stop any kind of a terrorism or any other international problems. Obviously, we have to approach the Security Council where the problem starts. So this is one aspect here that we all should think that how we can overcome. We'll come back to that little later. And secondly, in the application of international law among the countries, we have noticed one thing that the Western countries, the European countries approach towards international law is one, and when it comes to the non-European countries, particularly the South, the Western, the South, the approach is different. Most of the international law treaties, conventions, mainly they were consolidating the strength of the West, and it responds to the needs of the West. Even though when we, as the developing countries, even as a bloc, we try to negotiate, we try to modify the provisions to suit our needs. It has always been a problem for us to mend the provisions to to favor our the developing countries needs. This has always been evidenced. Even though the countries were all decolonized, most of the countries we become independent. We are all now equal. In the eyes of international law, everyone is equal, every country is equal, state is equal. You have one vote, one state. But it doesn't work like that. When a resolution is passed, when a convention is adopted, when a treaty is agreed upon, the influence of the bigger powers, the so-called colonial powers, they used to rule us. Their influence on the ruled is still there in the background. So that is another aspect. So because of this, what happens is there is a kind of imbalance. The developing countries, underdeveloped countries, they have to face the difficulties. They have to also mend their national laws, national policies to suit the development agenda of such those countries. So this has become a reality. There have been many attempts to stop this. Some of you might have read about the third world approaches to international law, where the scholars have come out very outspokenly to oppose the views of the West and the designs of the West that suppresses the interests of the peoples of the third world countries. Even though I don't like, most of the scholars, we don't like the third world. What is this third world? We should not put ourselves, or we should not name ourselves as a third world. But this is in the eyes of the West. They try to look at certain countries as this. The interest of the people, the interest of the reformers, the interest of the indigenous communities, the interest of the poor countries, they are not in fact taken into account. So this has become a major voice. The trial has become a major voice in the international discourse that whenever we make law, whenever we implement the law, whenever you expect outcome from the law, you have to necessarily look at the developing countries, third world countries, the states, and particularly you should look at not only state as such, you should look at the interest of the people who are living there. People-centric approach was taken by the trials. Third world approach to international law. And also increasingly we have seen, this is a history, we have seen that most of these third world countries, even though they have come out of the colonial mindset, colonial, the grip, they have become so-called the democratic countries, because of the colonization, excessive exploitation of the resources and the opportunities in these countries, they are not, one is they are not able to come up because the problems inflicted by the colonialism is still there.